5 seconds to go. Start. Taking all the factors into consideration, the family circumstances prevailing then, I am of the considered view that there never existed any indigent circumstances of the dependent family of late Shri V.C. Gopala Krishna Pillai to say that the family was in such crisis which would not have been able to overcome without job being offered under compassionate appointment. For the reasons given above, I come to the conclusion that the dependent family was not facing any acute financial distress or penury then which warrants the exercise of the discretionary powers to extend the benefit of compassionate appointment in this case. The question of relaxation of age arises only if the applicant is eligible for compassionate appointment. Since I have found on the basis of the judgment of the Honorable Supreme Court, based on which the scheme has been framed, that the applicant is not entitled for compassionate appointment. I am not considering the question of relaxation of age as per the scheme. As such, considering the matter in its entirety and also financial and familiar conditions present then, the request for compassionate appointment to the dependents of late V.C. Gopala Krishna Pillai, ex-clerk, Tirukkovillavatam branch, is not considered favorably. The application and representation of Shri Ajithkumar G.K. for compassionate appointment is therefore rejected. Denial of appointment once again left the respondent crestfallen. He thus approached the High Court by presenting a writ petition, initiating the second round of litigation, which has now reached this court. For the reasons assigned in the judgment and order dated 9th June 2016, a learned judge of the High Court allowed the writ petition. The order impugned passed by the managing director was set aside. A direction was issued to consider the respondent for appointment under the scheme of 1993 in the sub-staff cadre within 2 months. It was also directed that the appellant shall, in addition, pay a sum of rupees 5 lakh to the respondent as compensation for the reluctance shown in giving compassionate appointment in time. The appellant, feeling thoroughly dissatisfied, preferred an intra-court appeal. A division bench of the High Court, by the impugned judgment and order, dismissed the appeal with the exemplary cost of rupees 5 lakh in addition to the compensation directed to be paid by the single judge in the judgment and order under challenge. The division bench, expressing astonishment at the manner in which the appellant and its officers had dealt with the claim of the respondent for compassionate appointment, directed appointment of the respondent in the sub-staff category in any of the branches of the appellant within a month. The reasons for the above directions of the division bench are captured in paragraphs 17 and 18, reading as follows. We do not think either of the judgments placed before us by the learned senior counsel for the appellant bank commend us to cause interference to the judgment of the learned single judge. As noticed by the learned single judge, M. Mahesh Kumar and Priya Jayarajan have settled the issue under the very same scheme of the identical bank which was the appellant therein. In M. Mahesh Kumar, it was categorically held that grant of family pension and payment of terminal benefits cannot be treated as a substitute for providing compassionate appointment. The Honorable Supreme Court, having held so in 2015 in the case of the very same appellant, as rightly found by the learned single judge, it was audacious on the part of the bank to have passed an order in conflict with the decision of the Honorable Supreme Court by Exhibit P8 dated 8 September 2015 when the judgment of the Honorable Supreme Court was already delivered on 15th May 2015. Not only did the bank pass an order in conflict with the decision in its own case, but filed an appeal from the order dismissing the writ petition. We noticed that the learned single judge had granted rupees 5 lakhs as exemplary cost for keeping the bereaved family of the deceased wallowing in a penurious state, that too against the very provisions of the scheme. We also take note of the fact that the age relaxation directed to be considered in the earlier writ petition was brushed aside by the bank. That was the relevant and only consideration which should have been made on the totality of the circumstances, especially when the son had exceeded the maximum age only by 8 months. The receipt of family pension, which was found to be not a relevant consideration, was also projected as a reason for denying the appointment. We reiterate that a reading of the entire scheme, especially the special provisions enabling appointment of one dependent, even if another is employed, persuades us to find the rejection of the instant claim for reason only of a family pension and retirement benefit of rupees 3.09 lakhs to be against the spirit and tenor of the scheme. Canara Bank is thus in appeal against the said judgment and order. According to learned counsel for the appellant, reliance placed by the single judge and the division bench on paragraph 19 of the ruling in Canara Bank Supra was misplaced. First, because the matter at hand differs significantly from the facts and circumstances of that particular case, and secondly, the contents of paragraph 19 were merely observations and do not constitute a binding precedent. The question of whether terminal benefits should be included in determining the financial status of the deceased employee's family was neither raised nor resolved in the said decision. Even otherwise, the decision in Canara Bank Supra has been referred to a larger bench for further consideration. Additionally, the decisions of the single judge and the division bench are inconsistent with legal principles established by this court in a long line of decisions. In matters concerning appointment on compassionate grounds, it is essential to account for the terminal benefits as well as the family pension being provided to the family of the deceased employee while assessing the family's overall financial condition. Question of relaxation of age arises only if the applicant is otherwise eligible for compassionate appointment, subject to he being found suitable for any of the two categories of posts. In the present case, it was found that the respondent was not eligible for the appointment sought on account of non-existence of indigent circumstances, and hence the question of age relaxation or testing his suitability, which are the further steps in the process, did not arise to be undertaken. The High Court therefore applied wrong tests to allow the claim of the respondent. Per contra, learned counsel for the respondent contended that the scheme of 1993 did not contain any provision to the effect that the financial condition of the applicant's family is to be considered before giving employment on compassionate grounds. Paragraph 19 of the decision of this court in Canara Bank Supra was referred to in support of the contention that it was not open to the appellant. Stop.